Now, C. Arvind has apparently confessed to the ED, Anmol, saying that I was called by Manish Sisodia to the residence of Arvind Kejriwal. I was given a document which proposed that the wholesale margin of 12% should be there. If that's a binding statement, right, it establishes Arvind Kejriwal's role. And if Arvind Kejriwal feels it does not establish my role, he must still answer the questions. Anmol. So again, it's looking bad on Kejriwal the way he's dodging it.
Arnab, that is what Mr. Kejriwal has been asking time and again, that at least Enforcement Directorate must inform as to in which capacity he's being called. Is he called as a witness or as a suspect? And when they themselves have appeared before the court of law, stating that Mr. Kejriwal is not appearing, then at least they must wait for the court's direction. The matter is still sub judice and is to be heard on 16th of March.
So you're playing for time, basically. That's the point you're making, that you're using the court proceedings to buy time.
We are not using court proceedings. It is the Enforcement Directorate which approached the Honorable Court, and as per the court directions, will appear before the court and will let them know the reason why we are not appearing. And in which law is it written that if a matter is sub judice, he can still send summons?
One second, please. Why has the ED gone to the court? To deal with the issue of your non-appearance. You agree, right? So you need to look at the core issue here. The core issue, Piyush, which you need to explain to Anmol, is the issue of non-appearance. Now, if Arvind Kejriwal and Manish Sisodia have done nothing wrong, then you face the ED and answer. Was there a secret video call with the Liquorgate scam accused? You ask the ED, show me the proof, show me the evidence, show me a statement,
I'll tell you the core
testimonial, right?
I'll tell you the core issue.
But not to go. My point is not to go.
Arnab, I'll tell you the core issue.
You don't define the core issue.
The core issue is that the
core issue is the case in point.
I'll tell you the issue. The core issue is that the central government led by Bharatiya Janata Party introduced an amendment in section 45 in 2018 through money bill route. And the money bill route is an exception wherein the bill only needs to be passed in Lok Sabha and it does not require assent of the Rajya Sabha. The Bharatiya Janata Party knew at that time that they are not in majority in Rajya Sabha in the beginning of 2018. And that is the precise reason why they have made such amendments and introduced draconian provisions in PMLA Act, which has given untrammeled powers to the Enforcement Directorate and has reversed the burden of proof, which is not so in the criminal jurisprudence. The ED, moment they levels an allegations against any person, they'll be presumed as guilty. And at the pre-trial stage, they'll have to prove their innocence, which is almost impossible, which has also been stated by the Honorable Supreme Court in Niresh Shah versus Union of India 2017. In fact, they have questioned the constitutionality of Section 24 and Section 45 of the PMLA Act. So this is the reason they have, Bharatiya Janata Party led central government had used the loophole in the legislation to ensure that they bring such an amendment so that they can effectively crush the voices of the opposition parties, because they don't have anything to tell to the people of this country what they have done in the past 10 years.
Tuhin, just take my question as well. When are you summoning Ajit Dada Pawar and Hemant?